Abaud, immigration attorney. Today, the reason I'm here so spontaneously is because I want to talk about something specific that came out today. It was the final rule on public charge grounds. So if this is something that's been talked about, it's been in the works for a while, but the final rule was published today on the USCIS website. Although the U.S. Department of Homeland Security document actually says August 14th, but it does appear this is the final rule. So for those of you who don't know, the public charge inadmissibility ground is a ground on which U.S. immigration officers can deny an applicant's application for an immigrant visa. So this applies to you if you're applying here within the United States or if you're applying outside of the United States. Basically, if an immigration officer finds that you have become a public charge or are likely to become a public charge, that you can be denied on those grounds. The question is, how does an officer define who is likely to become a public charge? Well, that's what this new rule changes, because that is not codified at all. It is sort of left for interpretation, and this new rule is what is being changed. And it is going to be a lot harsher for a lot of people, and it's going to cover a larger group of people, and that's what we are going to talk about here. So when will this rule go into effect? It goes into effect October 15th of this year, 2019. So that means if you file for adjustment of status, or if you're applying abroad from outside the US, then you will not be bound unless you file that application on or after October 15th, 2019. And just to be clear, your use of benefits, if you apply for benefits today, that can still be considered. But if you file for adjustment of status today, you will not be bound by the new rules. So this is another reason if you've been procrastinating for no good reason, this is another reason to hurry up and file your case so that you're not bound by these more stringent rules. So let's talk about which benefits are included in those public charge admissibility determinations. So who can be considered a public charge if you've ever filed for any federal, state, local, or tribal cash assistance program, SSI or supplemental security income, temporary assistance for needy families, federal, state, or local cash benefit programs for income maintenance, supplemental nutrition assistance programs, also known as SNAP or food stamps, Section 8 housing assistance, Section 8 project-based rental assistance, public housing under Section 9 of the Housing Act, and federally funded Medicaid. Now that list is an important list, but this is where I really think there will be some serious changes for a lot of people. These are factors that are going to weigh heavily in favor of finding that a person is a public charge, and this is where it gets really important. So any person who is trying to immigrate, if that person has permission to work, but no current employment, no recent employment history, or reasonable prospect of future employment, you will be likely determined to be a public charge. This will weigh in favor of that decision. Now, who am I thinking fits into this group of people? I'm thinking stay-at-home moms, for one, because they're not considered, employed. And so perhaps this can target this group of people, unfortunately, who I find should not be targeted. Another group of people that can be affected by this is if you are the person trying to immigrate and you've been diagnosed with a medical condition that would require hospitalization or would interfere with your ability to work or go to school. So this could really affect you, if you're unfortunately been diagnosed with cancer, for instance, and it's so severe that you can't work, this could perhaps affect you. And if you're uninsured and you have neither the ability to obtain private health insurance or the ability to cover those medical costs, this could certainly affect you. And another group of people that this may affect is if you have been previously found to be inadmissible because you're a public charge by an immigration judge or BIA. So this is really, really important news. To add to this, the proposed rule also mentioned adding a Form 944, which would be the Declaration of Self-Sufficiency. This is totally new, and it's going to ask questions that include your taxes in the last 3 years, your assets and resources, liabilities and debts. It's going to ask for your credit history if you have one, and they're going to ask you to present one that's been generated in the last 12 months. And it's going to ask if you ever filed for bankruptcy and if you have health insurance. This is totally new. It is a draft that I reviewed, and I got these questions from a draft. It's not final yet, but this is something to pay attention to. If you're someone who perhaps does not have a good credit history, perhaps that's something you want to work on right now. So definitely some really important information here to be aware of, and to know that if you file on or after October 15th of this year, you will be bound by these new rules. I see some questions here. I'm sorry, I didn't see that until now because I've been talking. Okay, yeah, so you can, hi Min and hi Sambrana. So definitely I'd be happy to help you guys. You guys can call me at 310-803-3040. That's 310-803-3040. You can also go to my website at www.aboudlegal.com. I will type that right now. And there you can actually schedule an appointment online, and we could talk about. So thank you so much for tuning in, and I will talk to you tomorrow. Take care.